Well, thank you, Kaylee. Welcome everyone to Plenary Session 2 on the AWF, the Goldsmith Amici panel. This is, I don't know, the Umpty Dump panel that we probably all sat in on or participated in for this case. So I was running some slides, just pictures of the photograph and the Andy Warhol works during the break. I'll take, I'm sorry. I'll take a few seconds just to remind people, those who don't know. I'm sorry, I'm echoing. Those who don't know. I'm sorry, I'm echoing. So, Sandra, could you mute? And hopefully that won't be a problem going forward. Sandra, could you mute? Yeah. And hopefully that. Okay. Okay. So the case obviously boils down to the question of whether or not the Second Circuit got it right or wrong in deciding that Andy Warhol's work was not transformative of Lynn Goldsmith's photograph. Because we've had so many conversations, I want to make sure that we focus in on the theme of the conference. So today we're going to be talking about the impact of the case, as opposed to how it should come out, but the impact of the case on the panel participants, from the panel participants' perspective, on access for all. So we're looking at the theme of the conference. How does this case affect the role of IP in equity, power, and democracy in today's time? So by way of brief introductions, because we had a few, we have at least one of our panelists was not listed on the agenda, and one had incomplete information. So we have brief in support of Goldsmith, Jeffrey Sedlik, as a professional photographer, photography licensing expert, and he is a photographer and professor at the Art Center of College Design. We have on brief in support of Goldsmith, Philippa Loengard. I hope I pronounced that correctly, Philippa. Okay. And she is at the Kernochan Center for Law, Media, and the Arts at Columbia Law School. We have on brief in support of neither party, Kevin Madigan for Copyright Alliance. On brief in support of Goldsmith for the Institute of Intellectual Property and Social Justice and IP law professors, we have Lateef, Mtima. And full disclosure, I was also on that brief, but I am playing neutral today, so I will not be speaking from that perspective. And we have joining us as author of a forthcoming article, her Copyrights Lost Art of Substantial Similarity article, Sandra Aistars, is it Aistars? Did I pronounce that right, Sandra? And she is clinical professor of law and founding director of the Arts and Entertainment Advocacy Clinic at George Mason University School of Law. And then finally, as contributor to a brief in support of petitioner AWF for the Organization of Transformative Works and Electronic Frontier Foundation, we have Betsy Rosenblatt, professor of law at the University of Tulsa College of Law. So that's our panel of distinguished professors and experts in their respective rights. And I want to start by asking the question and give you, each of the panelists, 3 minutes. That's all you're getting in the uninterrupted time. 3 minutes on what your top concerns are about the impact of this case on issues of access, equity, and power and democracy. So I'm going to start with Lateef. We can't hear you, Lateef.
Yeah. And you didn't hear me say, oh, you would take me first, right? I was muted. Well, thanks for setting us up. And I'll try to be under 3 minutes. So our perspective and our concern in a sense, we supported Goldsmith, but in a larger sense, I think we might also be considered to be somewhat neutral, because our concern was principally in that if we have a relatively low threshold as prerequisite as to the kind of action upon a pre-existing work that will qualify as sufficient action to render the secondary work eligible for transformation status, that the concern is that fair use could become a proxy for misappropriation. That basically, we all know that we have a long history of various types of misappropriation of the expressive and cultural achievements of marginalized and outlier communities by mainstream and majority artists. And that one form of such misappropriation, or one tradition of such misappropriation, occurs when mainstream artists discover marginalized expressive works and the work of marginalized artists, and then bring that to mainstream communities. And oftentimes they're able to do that without adding very much of their own expressive creativity, to do not much more than what I like to call Elviserize, a pre-existing type of work. And the problem there is that not only are they, misappropriating someone else's or some other community's achievement, but it is difficult for the mainstream audience to detect that, right? Because they're completely unfamiliar with this pre-existing type of work, this pre-existing genre, because it's marginalized. And so as a result, not only are they not able to recognize the very limited, in these sorts of cases, contribution, not only are they not able to distinguish the fact that the contributions may not be, by the second comer, may not qualify as being creative, at all, but to the extent that the work is heralded and praised as being groundbreaking, et cetera, we're focusing in on directing that attention to the mainstream artist when it really should belong to the creator of the underlying work. And, oh, okay, good, I got it.
So save any remaining thoughts. All right, I'm gonna go to Jeff Sedlik.
Thank you very much, and I appreciate the opportunity to be here today. And yes, I am a photographer. I've been a photographer for 35 years or so. I'm pro-artist and I'm pro-fair use, and I think most visual artists are also pro-fair use. The problem is in the interpretation of the fair use. And my observation, being a professor of 25 years at the Art Center College of Design in Pasadena, is that my socially or economically disadvantaged students have 1,000 times more difficulty in achieving success and breaking through to be successful artists, in great measure because the moment that they create their works, the moment that they publish their works, or that their works are published by others, they are taken, they are adapted without their permission, they are exploited by people and by organizations that have an economic and social advantage over them. And my students, who are then nascent photographers, have a very difficult time of overcoming that. It's all against them. They can't make it. And there are a lot of great works that will never be made because young artists in this generation and in the current generations will not be able to afford to create new works. And we see a lot of surveys by my peers in academia saying, well, we talked to a bunch of artists and we found that they don't really care whether they receive control over their works or their ability to limit derivative works or the ability to license them. And I think if you ask the follow-up question of these artists, well, how do you and will you make a living if you can't receive any economic or promotional benefit from your own work, and if everybody can just create similar works without your permission based on your works? They'll say, well, I have a significant other, or I have a trust fund, or I inherited money, or money's not a problem for me. And it's those artists who want to spend their full time focused on creating work for the benefit of society that do not have the economic means to do that if they can't protect their works, that are the focus of the problem. And I'm going to use my remaining 30 seconds just to clear up a couple of things. So first of all, full disclosure, I was the expert witness engaged by Lynn Goldsmith in the district court level, and the one mentioned by the Second Circuit, the expert mentioned as having opined that there was competition for licensing of the two works. I'll just clear up a few things and then I'll step back. So first of all, the color image that was shown here on the screen is not involved in the case, was never given to Warhol or to Vanity Fair by Lynn Goldsmith or her agency. It was only the black and white, one single black and white photograph with a delivery memo for that black and white photograph. The color photograph was introduced by the Warhol Foundation into the picture. Number two, there was a license that said you can only use the image one time, only in a specific issue of Vanity Fair. You can only create one single illustration. No other reproduction is allowed without the express permission of Lynn Goldsmith. And lastly, I'll point out that that was a commonplace, routine type of license called an artist reference license that has been in the art world and the publishing world for close to 200 years. So when a publisher or an artist wishes to make a new work based on another work, they go to the rights holder and request that right, and an artist reference license is issued for the benefit of both parties. And with that, I'll step back.
Thank you, Jeff. Kevin?
Yeah, so first of all, thank you, Tuneen and Lateef, for inviting me to speak on the panel today. So I think this is a very important case because it sort of presents a crossroads for transformative use, and one that, depending on the outcome, could result in a system where one class of creator is sort of favored over another. And what I mean by that is that if the Warhol Foundation's transformative test, where sort of any subjective opinion or stated intent regarding different meaning or message would qualify a work as transformative, if that test is accepted, it would, allow for nearly any appropriation art to be deemed transformative and then weigh heavily in favor of an ultimate finding of fair use. And at the same time, that would strip copyright owners of the underlying work their derivative use right. So because the things that might have been deemed derivative would all be transformative under the first fair use factor. There was a claim made by Warhol's counsel at oral arguments that a finding in favor of Goldsmith would threaten all appropriation art and chill creativity. But they didn't acknowledge that those artists wouldn't be able to create at all if not for the existence of the underlying original work. That was something I wish was talked about a little bit more in oral arguments. But if the derivative use right is weakened or made obsolete, those original creators may have less of an incentive to create because they would have no licensing markets for derivatives, and the whole foundation of our system, copyright system, would be put in jeopardy. And then just quickly, the second reason I think this case is really important is that it gives the Supreme Court the opportunity to sort of temper the expansion of transformative use that we've seen occur over the past 20 years or so. So I think there's a chance for them to clarify that transformative use is really just one sub-factor of one factor of a fair use analysis. And then lastly, I'll just say that I think your and Lateef's brief touches on how we don't want to vest these decisions over transformativeness in an established mainstream artist or an expert witness that they're able to hire. And I believe that the Warhol test would risk harming sort of the less established or marginalized creator who doesn't have an established audience or, you know, the resources to go out and hire expert witnesses.
Thank you, Kevin. Betsy?
Thanks. I should note that I was actually involved in 2 briefs on this case. They're consistent with each other. I signed on to the copyright law professor's brief in support of petitioner, and then I wrote the Organization for Transformative Works and Electronic Frontier Foundation brief. It's sort of like TV credits. The one that has my name on it isn't the one I wrote, and the one that I wrote isn't the one with my name on it. But I'm here to talk mostly about the OTW one, which is the one that I feel closer to, although they're very consistent with each other. And the point that we made is larger. The points that we made is largely that this case isn't just about this case. It isn't just about photography norms. It isn't just about visual art. It's about fair use in general. And that means that if we want a fair use law that includes access and inclusion and the ability to use existing works to comment on society, rather than, for example, to comment on the original or to comment on more subtle things, we need a fair use law that allows that. So we talked a lot about how fair use law needs to grow to deal with the growth of copyright law. Copyright law is now hiding in lots of things that we wouldn't expect it to hide in. And for that reason, fair use becomes all the more important as our valve for that sort of thing. And this is particularly true of the need to critique things in the era of the DMCA, where the relationship between recognizability and having your work disappear is particularly, I think, poignant for a lot of people. So we identified 3 problems with the test, and then also made an additional suggestion. The first problem is that being in the same genre or medium does not mean having the same meaning, message, or purpose. And that's may seem self-apparent, but it was not something that the Second Circuit really recognized. So there are lots of things that are in the same genre and medium that do not have the same purpose. And those include, for example, subtle parodies and critiques that use the same medium to function. The second is that while transformative meaning may sometimes be very easy to observe, as with, say, broad political statements or broad parodies or overt political statements, they often involve much more subtlety. And it is reasonable to ask about the intended audience for a particular piece, not about, say, the judge's opinion on whether something has a different meaning, or something that pretends to be objective but wouldn't be. That may not be an issue here. Right? The intended audience for this piece may be the general public. But if we look at, say, Campbell, we see the intended audience is relevant and should continue to be. We can't ignore people who are likely to see commentary and criticism, even if the general public may not be.
Thank you, Betsy.
Okay.
I'm gonna.
Yep.
You can fit it in, but I want to keep this out 3 minutes. So Philippa, and welcome, Loletta.
Thanks, Tuneen, and thank you to Lateef and Tuneen and everyone who organized this conference. I'm so honored to be a member of this esteemed panel. Truly amazing. I, as Tuneen said, I wrote in favor of the respondent in this case, Lynn Goldsmith, and I obviously believe in the legal concepts that her counsel argued, and believe that they were superior. to those of the Warhol Foundation. But I think that there is a bunch of other issues, and I think Jeff and Kevin really touched on some of them very well, and thoughts that I had. But I'd also add that this is sort of a David versus Goliath. I'm first going to say that I don't think this is the greatest case to go before the Supreme Court to make this determination of transformative use and what that means and what that is. And I think that one of the reasons is that this is just an unfair playing field. Now, it's not to say that that has not created law before. The Prince versus Cariou case in the Second Circuit certainly led the way in David versus Goliath cases, and I think just reinforces some of the social justice issues that I see present here. You know, as Jeff said, reference licenses have always been the bread and butter of a photographer's work. What I think what is getting lost a little bit here is that both Warhol and Goldsmith were at the top of their each professional, you know, games when these works were done. Warhol obviously was better known, but Lynn Goldsmith is very well known in circles of photography, especially in music photography, and certainly is not an unknown person without significant skill and esteem among her peers. And so when the Orange Prince came out, which was the one that came out in 2016 in the Vanity Fair tribute issue to Prince, you know, she asked for a license fee, which is a reasonable thing. If this was made, and it's still sort of up in the air as to whether it was made at the same time as the other prints, you know, whether the non-Purple Fame prints were all made together or not. In any case, it's a derivative work of the first Purple Fame, in which case she deserved a license fee, a second license fee, if she agreed to allow its production at all. But it was a reasonable thing to ask. You know, I'd like compensation for the work. It was not an aggressive ask in any case. And somehow this has turned into a battle where someone asked for what they were owed, and instead a 200-pound hammer came down and said, not only are we not going to entertain this, we're going to sue you in federal court, which is very expensive. We're the Andy Warhol Foundation. We have literally millions and millions of dollars. And as I say, Lynn Goldsmith is successful, but I think Jeff would agree that even the most successful photographer is not as wealthy as the Andy Warhol Foundation. And we're going to take you to court, demand that you appear if you want any hope of us not infringing your work further, and we're not going to pay you. So I have a problem with that. I have a problem with this idea that the individual can be so easily almost, and I don't like this term at all, and I was trying to think of another term, and if someone has one, please jump in, bullied by the bigger giant in the field, in order to get their way. And if Lynn Goldsmith, who is successful and is not a person of color, is not a minority, is not a lower income, can be put in this situation, then I feel that it's only portends worse for those with less access to a pro bono lawyer and to knowledge of the legal system.
Thank you, Pippa. Sandra, I see Bamadi. I'm going to let Sandra and Loletta go, and then I have a couple of things to recognize, and then I'll get to Sandra.
Sorry, trying to unmute. Thank you very much for having me. So my view of this case is that some of the equity, power, and democratic goals of copyright are advanced if artists can appropriately control both the commercial exploitation of their works while still being able to draw from the expression of others when creating new works. And I think that's pretty much what everybody on this panel would agree with. And to me, the reason why I didn't take a position in this case and didn't take a position for or against either artist on the issue of transformative fair use in the case is because I don't think that this case should be decided on fair use. I don't think it should even be before the Supreme Court on those grounds, because the Second Circuit and the Southern District of New York both refused to do a substantial similarity analysis. And I think if they had done a substantial similarity analysis, we would be in a far better position to make these assessments in an equitable fashion. Substantial similarity provides the opportunity to make evidentiary findings about what is original about a work and therefore protectable about a work. It also allows us to trace protectable expression from one work through another work and determine whether what an audience values in one work is expressed in the second work in a way that that audience would recognize it. People seem to have this perception that avoiding doing that evidentiary work is somehow procedurally efficient, and that by jumping into a transformative fair use analysis, you can decide these cases on higher principles without getting your hands dirty in the messy business of looking at art. But in fact, that's exactly backwards. When you sidestep doing the evidentiary work, you end up in a situation where you're shifting the burden of making fact decisions to the Supreme Court. And that never serves the value of fairness, equity, or democracy, because what you're doing is deciding the facts of one case between two parties and then trying to apply that to every artist and every artist's future creation. And if we're worried about judges judging art, then we should be incredibly worried about judges judging a dispute between two artists in one case and then reaching out into the future and trying to imagine what every artist in every potential creative endeavor that they might imagine would do, and create a standard in a transformative use context that would encompass all of those creative endeavors. Lateef and Kevin and Betsy and Philippa actually made my points for me in the things that they all said. Lateef was worried about marginalized communities, the originality in their works being, sucked up by majority artist communities, and that being the originality being overlooked and being commodified by others. That can be fixed by a substantial similarity analysis where you look at that original expression and protect it, right? If you don't do that factual analysis, that's where you have a problem in the transformative use test. That's where the minority communities suffer when they don't have the chance of making their original, their argument about what's original about their works. Kevin made the similar argument about the subjective intent, that artists are going to make a broad argument about the subjective intent of their works, and every time that they assert a claim that, oh, I made something transformative here, it'll be broadly accepted on the basis of their assertion, and that's going to be a tragedy for transformative use. I agree, absolutely. But that's why we have to do a substantial similarity test on the front end so that we know what's going on the facts, so that we don't make those sorts of broad assertions. Betsy talked about the fact that similar genres, works in the same genre, don't necessarily have the same meaning or message. Of course not, right? But that's why you do a substantial similarity test. And that's how you understand that they don't have the same meaning or message. Same thing for transformative meanings being subtle and nuanced. Yes, you look at the audience, the intended audience. Where do we do that? Substantial similarity tests. That's what the actual legal standard is. I see that Tuneen wants me to.
I want to jump in because that interactive, I want us to do that, but I do want to give everybody their 3 minutes. So the last on the 3 minutes is Loletta, and Loletta, we're talking about why the impact of your respective position on access for all, on the role of IP in equity, power, and democracy. And I know you in particular had a broader, this is bigger than copyright alone perspective. So if you could, in your 3 minutes, speak to the impact from your view.
Yeah, I think from my perspective, and I apologize for my lateness, and I am happy to be here. And so, of course, I missed most of the comments, but I heard Sandra summarizing some of what Lateef had to say, and I think what he mentioned applies to basically my theme around what the larger impact of this case might be, and that is artists. There will be a tendency, if the Supreme Court sort of sides with how Warhol's counsel was arguing the case, there to me is the potential for artists and authors from marginalized communities to have their rights eroded by parties from majority communities or deep pockets that can have the funding to come in and say, I've made some minor changes, so therefore my work is now transformative, without having to give attribution or compensation to the artists from the marginalized community. And so the theme for my remarks is unfair competition, which I came in just as Betsy was mentioning unfair competition, and I thought, wow, somebody else, another kindred spirit. But I'm looking at unfair competition and fair use, and particularly assessing whether a work is, when and how a work becomes transformative. So I look at copyright protection through this lens because it promotes a system that honors the social and societal implications of the copyright law. I say that the law should promote accessibility and equitable protection in both the protection and exploitation of the creative and innovative works. So that also includes reaping the commercial and social rewards of the creative process. Now, we all know that the purpose of the copyright law is to foster creativity. To achieve that, some copying is necessary. But the question is how much? And when do we go too far? So I feel like that there should be a test that looks at, as the government's attorney was arguing, the purpose of the work. And not only just the purpose of the work, is there some justifiable reason for copying from the original work? And is that justification found in the purpose of the work? So just to say, as the petitioner's attorney seemed to be arguing before the court, just because you have a changed meaning or message doesn't give you a new purpose. Because what that does, if you can make these minor tweaks to a work based on some subjective intent about message or meaning, or even purpose, that opens the door to unfair competition, which is what we had in this case. Because now, if you talk about the Orange Prince, you have two works, the original work and the work that borrowed from the original work, competing in the same market. So how does that incentivize the purpose of the copyright work, which is incentivizing creation? Because again, you could potentially have marginalized authors who are disincentivized to create if their works are only going to be taken and competed with unfairly in the marketplace.
Thank you, Loletta. All right, so there are a couple of themes so maybe this is not surprising because we're all here at this conference, right? But you all seem to agree, right, on some basic premises, right? There's not enough fight here. There's not enough conflict. One of the things that really stood out to me that you said, Jeff, was you said you are pro-artist and you are pro-fair use, right? And even I think the Institute is pro-artist, and artists necessarily need fair use, to do their work. And I think to Sandra's point, I think it was you who said it, that this was not the case. Was it me? oh no, it was Philippa. This is not necessarily the case to decide these issues. And so I'm going to take that and ask, well, why not, right? Because isn't this the clear, well, apparently it's not the clearest example of when there is and when there isn't, fair use by transformation, at least on that point. But to Sandra's point, is the problem here that the court didn't really explore it thoroughly enough, the substantial similarity? Isn't that part of, how you get to a fair use analysis? Do you jump right to the affirmative defense? Or if we look at that substantial similarity that we know courts do, isn't that what we're asking the court to do when we ask the question, is this transformative? Such that courts do that all the time, substantial similarity, but the argument is that courts aren't qualified to judge whether or not something is transformative. So I'm just throwing that out. And we had a question also, where'd she go? You could raise your hand or put your questions in a queue. I'm going to take them, but just panelists, jump right in response to that, and let's just get some conversation going. So Jeff?
Sure. Well, in response to that, and I know that the methodology of creation of the work is secondary, but I want to make sure that some misunderstanding is cleared up briefly. So Warhol, through Vanity Fair, received an 11x14 black and white print of a headshot of Prince. Warhol or his associates placed that in front of a camera, took a picture of that print, and then burned silk screens from that picture, that photograph of that print. So the silk screens are burned from a high contrast photograph, then ran ink through the screens onto the substrate, whatever, canvas or what have you. There was two of them where Warhol projected the photograph onto paper and then traced the projected photograph on the paper. Not a lot of people understand the methodology that went into creating this, but when you place one over the other, the black and white print over the silk screens or the others, you can see that the actual photograph is photographically reproduced through the silk screen process onto that substrate. And I think there's a lot of confusion about purpose, meaning, and message when it comes to at least the visual arts. I can't speak to other art forms. But when visual artists create works, they typically create them for myriad purposes. So the purposes are virtually unlimited. And so one of the problems has been that artists tend to be, at least visual artists tend to be, they speak with their art, right? So they're not eloquent at deposition. They fail at deposition to be able to adequately describe what their intent was and what their creative contribution or creative subjective decisions were when they created the work. But even Lynn Goldsmith never actually said that the meaning and message that's been attributed to her to a statement to her was what she said. Vulnerable and uncomfortable person and a vulnerable person, vulnerable human being. That she didn't say that was the meaning or message of her work. She was asked to look at a print of it and say, what do you see there? That wasn't her intent when she created the work. Her intent was to create a depiction where she controlled many of the aspects of how that depiction would be rendered through thousands of creative decisions, and then to put that out into the world so that people through their life experience would interpret that in whatever ways that they would interpret it. And that's how all visual artists work. We have certainly a number of different purposes, such as I want to see this used by other artists. I want to see this used by, on shirts or in museums or what have you. But there's never really one purpose, one meaning, or one message to a work.
Okay. All right, so we got lots of hands up and some, including the panelists. So I'm going to take Tim and I'm sorry, Bamadi, because
I
she had
really
your hand
want to
up
comment on that previous
first.
question, actually,
Okay,
if
go
we
ahead.
can.
Sure.
Because I think it's really important to remember that there are 3 questions that you must ask. And we don't want to blend them together. And I think Sandra's point that that we skip steps. As law professors, we tell people don't skip steps. The court skipped steps. And in so doing, it ended up mushing together tests that really need to be done separately because they ask about different things for different reasons. So the first question we're asking is whether there's been copying in fact. We know there's been copying in fact. Copying in fact is, it's very easy to think copying in fact is the end of the story. It can't be, it's the beginning. But the second question is the misappropriation under 106 question, which is where substantial similarity lives. And that's asking about substantial similarity of copyrighted elements. Now, that means that we have to distinguish between things that have thick copyright and thin copyright. We have to actually ask what's copyrighted about the work and what's similar between those copyrighted elements and the thing that was copied. And then the third question is whether there's a transformative meaning or message as part of a much larger fair use question. So I think that Sandra's exactly right, that by the time we get to fair use, we're asking something that is very different from what this court asked. And that's a big problem. But I kind of want to respond to Jeff's point. I don't think that anybody would, well, I don't think anyone in this room would argue that we need to be asking about the subjective intent of the author of the underlying work, which it may be obscure at best. I do think, though, that we need a way to ask about whether something has a different meaning or message or purpose. And the only way we can do that reasonably, according to my thinking, my way of thinking, is to look at the intended audience for the follow-on work. Do they think this means something different from the initial work? That's what the Supreme Court asked in Campbell. It's a good way of asking. And it does, I think, allow for certain kinds of subtleties that maybe the underlying artist didn't intend or didn't understand how to express or articulated very clearly. It doesn't actually matter how the underlying artist characterizes their work. What matters is what the intended audience, the follow-on work, sees.
I would definitely agree.
If I can just add on to what Betsy was saying,
Sure.
to those 2 points. And the intended audience test actually is part of the substantial similarity analysis. So if that is properly done at the fact-finding stage, that evidence is there for the Supreme Court or for the appellate court to rely on if they have to judge whether the transformative use test has been done properly. And I also want to point out 2 things about the difference between the substantial similarity test and the transformative use test. They ask 2 different questions in different ways. So Betsy pointed out very properly the legal analysis, the legal questions that are asked, but it's also important to think about the perspective from the framing of those questions. So at the substantial similarity phase, you're asking from the perspective, let's say the plaintiff, okay? Although it wasn't the plaintiff in this case, and that's also important. And the plaintiff in this case was the Warhol Foundation, okay?
Right. So from the perspective of the copyright owner of the original work.
Let's say. So from the perspective of the first artist, you're asking, was too much of the work of the protectable expression appropriated by the second artist in that work? And would a qualified audience, the intended audience viewing the work, recognize it as such and view that second work as a replacement for the first work? The view that the aesthetic appeal is the same between the 2 works. That's what you're asking in the substantial similarity test, but you're asking it from the perspective of the first artist, and you're saying, did the second guy take too much of my work, right? In the transformative use test, you're asking it from the perspective of the second artist and the second artist's work. And the second artist gets to come in and say, all right, fine, I was infringing, but look what I added. Look at the additional meaning and message and the benefits that I'm bringing to society with my work. And so why do you think Andy Warhol Foundation was framing this up as a transformative use case rather than a substantial similarity case? Which question do you want to answer as a defendant? Do you want to come in and frame your case as a substantial similarity case first off, or as a transformative use case?
So to that point, but you don't even need to get to transformative use as a defense, as the first step of a fair use defense, if you haven't actually inappropriately copied, right? So I think they are very related, but like you said, it twists. So I want to go to is it Bamati?
Hi, thanks for taking my question. It's actually Bamathi. It rhymes with
Bamati.
Bamathi. The accents on the first
Bamathi.
syllable.
Okay.
TH. Thank you. I appreciate that. And I want to just step back for 1 second and say thank you so much to Lateef and all the wonderful folks at IIPSJ. I so appreciate your doing this conference because I think it's really important. And that gratitude also speaks to my point, Tuneen, which I felt was you framed it so beautifully at the beginning. You said, this Warhol case we're going to be talking about till, I don't know, next June, and then 10 years after that as we unpack the opinion. But for now, you framed it as how does this have an impact on issues of social justice? I'm not going to give all the reasons that I think that Warhol wasn't a great test case. I totally agree with Pip on that front. But one of the reasons is, I care about more than anything, everyone knows that, including my students, because I say it 5 trillion times a day, about the rights of people of color and other marginalized people. And in this case, you have, white plaintiff, white defendant, and you've got the only person of color involved here is the subject of the photograph, who obviously does not own rights in their image of themselves, Prince, the artist who was the revered artist who was at the center of this. But I want to ask, I want to come back to your question that's so important, Tuneen, which is, given the everybody cares about artists, whether it's a transforming artist or the artist whose work was allegedly appropriated or otherwise, we all claim to care about artists. Where we come down on the question of copyright isn't because of how we feel about the artist, but I feel like the background is taken as an even background because copyright law is purportedly written in a facially neutral way. We forget that there's an impact question as well in how this case comes out for artists and for artists of color. And how do we take that, as I think we should, into the equation? And one of my questions is, in a David and Goliath situation, Pippa, to use your analogy, which I think is fair, in a world where artists of color are constantly being appropriated, continually culturally appropriated across cultures and across lines, right? If you ask artists of color, where do you come down on this? Maybe we need a little information about how Jaquel Knight would feel about this, or how would Faith Ringgold feel about this? And I read a lot of articles from people who are opposed to too much, as they say, too much protection, locking up the world of arts. And they say, oh, it's really important that marginalized artists keep things free, but marginalized artists are suing for their rights and claiming their rights and staking copyright in their works as they were never able to before. Copyright is a right that can also be wielded as a weapon and as a tool and as a protective shield. And let's not forget that backdrop, right? Now, if you ask Hank Willis Thomas, it becomes complicated, right? Because you ask him one way and Peter Magubane might feel quite the other way about this question. These are important things to consider when an artist of color borrows a work from another artist of color. It does become complicated. These aren't bright line rules, but I thought that the beauty of this particular panel was to talk about the impact of Warhol on issues of social justice. And to me, this backdrop of our country, we're beginning to recognize that issues of color permeate everything. Critical IP is beginning to make that recognition, but I feel that we should also think about how copyright empowers artists of color. And in the case of Warhol, in the case of a small artist claiming rights in their creative original work. It was very disappointing to be at the court that they were like, oh yeah, it's just a photograph. No, it's not just a photograph. A photograph under Cerrone is an artistic work. It's an artistic work that's being borrowed from, and yes, that's different from a soup can. And with an artist of color, I think we really should home in on that point. Thanks for my comment.
So to your point, I want to pick up a couple of things that I see in the chat. One, Jasmine made the point that the biggest value is getting some clarity about how fair use functions for visual works as opposed to text works. That there is, and I think that's a point that the Institute's brief made, that the test might and should look different if we're talking about aesthetic works, when we're just looking at something and the viewer has to decide whether something is transformative. Necta said if the transformative use would be allowed to Warhol's use, would this now lead to the fair use exception failing the 3-step test under Byrne and Trips, as would not consider the legitimate interests of the rights holder? So that's a, I think an equity issue. And Sarah Bernstein said, as someone with an art degree, I'd like to contribute that learning how to talk about your art is a big part of art education. So she does not agree that artists are categorically not good at talking about their work. But to that point, I think not all artists are art educated. Not all artists are formally educated. And so I would worry about importing that a standard of what you should have learned into how we work with the messaging. But I acknowledge that the bare statement that all artists don't know how to speak may conflict with what art education is. So I want to go to Tim, and then Philippa, and then Sandra.
Thanks. I just want to say this great panel. Really enjoyed hearing everyone's perspective, and would like to hear folks' thoughts on this perspective that I have on the case. I don't think I'm really happy with how either court, district or Second Circuit, has handled this so far. The more I think about it, I would like to have seen a trial in this case, and I think this maybe lines up somewhat with what Sandra was saying. Is to have a trial, develop substantial similarity and fair use. And I'm thinking about with Google versus Oracle, putting a fine point on fair use is a mixed question of law and fact, ultimately be decided by a judge, which I think I'm fine with as a policy perspective. That's probably maybe the least bad way to do it. Maybe this is one of those subsidiary factual questions that the court mentions in that case that could be posed to a jury, something like, does work B communicate a different meaning or message than work A? And get a jury's perspective on that, a factual finding that then a judge could take into account. And it's not just one district judge or 3 Second Circuit judges telling us, what they think about that. And then as a related final note is in something like that, to me, this makes me think we could reconsider perhaps the copyright law's hesitancy towards survey evidence, that in some hard cases, potentially hard cases like this, we're meeting our message, could survey evidence be useful and relevant? Would it be worth the time of the court to consider that? And then perhaps relatedly, we could exclude evidence of somebody like Warhol's subjective intent. If we're worried about that, which I think it is as a concern, don't let the jury hear the artist testify as the meaning. Let the jury look at it themselves, and be interested in folks' thoughts on that. Thanks.
Philippa? Thank you, Tim.
So I think those are all excellent points, Tim. There's a couple notes. One is this, just to clarify, because I'm a nerd, the Second Circuit did do a substantial similarity test. You can say it was too brief, it wasn't what you wanted, but they did do it. The district court did not. And a substantial similarity test is a starting point, absolutely. But if it fails, then we end up in the same bog, which is how we got here. I think that the quick answer I have to Tim is that there is no good solution. And so we're looking for sort of the better solution. I'm not even gonna say best, because there's not even a best. There's like a middling, could we maybe do better, right? So a jury, you've got other problems that get introduced, right? Who is a jury? Does it represent a wide swath of people? We know the jury don't tend to represent a wide swath of people. Does it matter that they don't represent a wide swath of people? Do we care about that? You know, I think it would depend. The parties would say it would depend on what the jury thought. So then you bring up the idea of surveys, which work really well in trademark, and have the potential to do better than a jury. So you got more than 12 people. That's a step in the right direction. It's an interesting thing about when we are supposed to judge this interpretive meaning and, you know, and message. And I think purpose is separate than meaning and message. So we're looking at meaning and message, which I argue does not belong there. But if we are, that's fine. It would be more of character to me. But in any case, when we look at that, are we looking at it when Warhol created the work? So in 1984, are we looking at 2016? Are we looking at 2022? What does the, you know, meanings to people could change over time? And so that is another factor. So that's why I say it's a better middling sort of assessment. I don't know that there's an answer, but I don't think there's a way to get there where it's equitable to everyone. I just like to say about burn. All of fair use could technically be against the legitimate interests of the rights holder, but there are exceptions just for things such as fair use. So I don't think we'd run into a burn problem. You can rule against an original author and still be compliant with burn.
Thank you, Philippa. Sandra? Sandra?
Sandra, you're on
there we
mute.
go. So something's going on with the, oh, there we
Okay.
go. Okay.
The reason I was saying the host muted you, so anyway, so quick point on the Second Circuit did a substantial similarity test. They did a substantial similarity test in their revised opinion after they had already ruled on fair use, and then they didn't actually do a full substantial similarity test. So I don't really think that counts as doing a substantial similarity test as an evidentiary exercise. In terms of the other issues that the questioner brought up, I think they are very interesting in terms of judging what how an audience reacts to a work. But I think in some ways, because we're looking at this through the lens of transformative use and measuring, you know, what has and has not been transformed, rather than looking at the evidentiary question kind of at the outset, we're making this a lot more complicated than it need be. There are some pretty basic facts that you can even look to understand what a work is intended to be and how it is intended to be perceived by the given audience. And I think there was at least some of this analysis going on kind of in the subtext of the Second Circuit's opinion that I wish had been played out a little bit more in terms of tracing the original expression of Goldsmith's work and that they could have played up. So for instance, they were talking about, you know, the lighting, her lighting showing up in Prince's eye, the reflection in Prince's eye. And if they had made the case that like, you know, this is how she was portraying him as a vulnerable being, like she used the lighting to, you know, to set it up, and look, it's showing up in the, you know, in the Warhol work. And an audience of Goldsmith's work would recognize this as, you know, a tool of Goldsmith expressing herself, injecting her personality into her work, that would be a persuasive analysis, right? You could look to even more simple things, right? So if there's a title of the work, or if there's, something, a time period or whatever that we can look to in other works that say something about the work and the artist's intention. We're very focused on this particular case, but just thinking more broadly, people throw out all these straw men as if we need to analyze the psyche of the artist and, understand what they ate for breakfast that day to understand the meaning of the work. But that's not, we don't need to get into that great degree of detail as a copyright question. As art critics, yes, maybe we want to know all these things, but as a copyright question, we want to kind of know the basic facts that we need to know as an evidentiary matter to be able to trace the original protectable expression from one work to the next to make that evidentiary assessment.
Okay, so Jeff, I want to turn it to you, and also so the comment has been made that this was not the best test case. Not the best test case on one hand, because it's not a marginalized artist. It's someone who's known in their field versus another artist known in their field, although one obviously had deeper pockets than the other. From a photographer perspective, how do you respond to that assertion that this is not the best test case on the issue of transformative?
Well, first, it's not the cleanest case because we have a license, and a license was requested and granted, a very limited license for one illustration to be made. And I think personally that a better case would have been somebody found a work on the internet and made a derivative work out of it, and let's look at it in a more clean sort of way. And certainly, as you mentioned, there's not a directly evident aspect of social or economic disadvantage, although certainly the Warhol Foundation has a magnitude greater wealth than the photographer here, who has raised money from friends and family to help to defend against this lawsuit, in which she was a defendant, not a plaintiff. Well, there was a counterclaim. There were a couple things that I heard that I just wanted to comment briefly on. One is that socially and economically disadvantaged people have a more difficult time protecting their copyright because they can't afford to register their works. When you register your works, you can then pursue statutory damages, but most importantly, perhaps the reimbursement of your attorney's fees and costs, which can be very, very substantial. And not only can disadvantaged people not afford the cost of registration, was $55 or so for a visual work or group of visual works, and in some cases $55 per work or different amounts per work, but they can't afford the time that it takes to complete and submit a registration because they are working for a living in addition to being working for a living as an artist. So they typically will be an artist and have a job and potentially struggling. So that is an issue that I wanted to raise. The other issue is my disappointment with some of the justices basically referring to the photograph as it's just a photograph of a person, it's just a photograph of Prince. And that was mentioned 2 or 3 times while giving short shrift to the creative process that goes into it. There is a reason that if you hire 100 photographers to take a photograph of somebody, to create a portrait of somebody, you will get 100 different portraits. If you hire me or another photographer to create portraits of a person, even within my one photo session, that person's going to look entirely different from photograph to photograph, depending on what I choose to do and my creative decisions, subjective creative decisions that I make in lighting, in lens, in perspective, in background, in posing, in my personal interaction with that person, which you can see reflected back in their eyes and in their expression at me. So you line up a bunch of photographs of Prince, he looks entirely different in each one. It's not just a photograph of a person. These were artworks depicting a person in the way that was determined by the photographer. And lastly, I'll point out that the meaning and message put forth by the Warhol Foundation in this case was created by an expert who does not read minds. Warhol, when he talked about his work, I could sum it up as, I want to make money being a professional artist. I mean, there's quotes from his books that you could sum up just like that. And I'm not saying that his work was not influential, that he didn't say important things, etc. But I'm saying the way that he referenced his work in writing, in his autobiography and otherwise, was I want to make money doing commercial work.
Okay. Thanks, Jeff. So we're coming up on time, so I want to corral our last thoughts back to the theme of the conference and ask the question. So what would it mean for us as an IP community? Would it be acceptable if the court decides to rule in favor of Warhol and say fair use is, or not fair use, but transformativeness is satisfied, even where you can see the full photograph in the picture by the second artist's projected message, right? Not based on a reasonable observer test. What is our response looking down the line to protect artists from the impact of such a decision? So that requires us to think about what is the impact. We've talked about, Jeff made a point, artists right now can't afford to create for a living because as soon as they publish their works, they get exploited and they can't afford to go to court. And so as this collective thinks about, progressive IP, right? What would we do in response to opening the door to allow this kind of exploitation of pre-existing works, knowing the impact? Because the impact has been, I think, discussed. So Betsy and then Loletta.
Yeah, so I will, I'll answer this by, I think, also answering Bhamati's call to action, which is absolutely recognizability cannot be the test. That's relevant to substantial similarity. And if recognizability were the test, we wouldn't need a fair use exception. Because you need recognizability at the initial stage to even get to fair use. So surely appropriations of entire works must be capable of being fair use. And then the question is, when are they capable of being fair use? And the answer is, like all questions in law, gotta be, sometimes it depends. And I think what we may disagree about here is what it depends on and how often. But to answer Bhamati's call to action, I think she's absolutely right. You're absolutely right. The key question here is how best to make legal standards that serve underrepresented artists and artists of color. And the big question is how to do that. To my mind, the key is going to be a flexible test with broad space for fair use. And the reason for that is because there's no question that artists of color get appropriated and misappropriated a lot. There's also no question that artists of color are disproportionately targeted for takedowns based on copying that undermines hegemonic power structures. And we need to balance these things. So turning artists of color into plaintiffs, given the cost of litigation, can't be the answer to that. We need some other answer to that. And I think that answer lies in a flexible fair use standard, really takes into account who's the audience for works and whether we see subtle criticisms in them.
Loletta?
Yeah, I just want to follow up on Betsy's point. I think we can't you can't separate meaning and message from purpose. And then if we tie those together, there has to be justification. Why was the copying needed in the first instance? And I think that without understanding the need for the copying, then copying is just open for anybody to say, I want to use this work to further my own expression. For example, we talked about the screen printing process, how the work was, there was actual, in fact, copying. Well, that particular photograph wasn't needed for Andy Warhol to make his orange prints. So why? What's the justification? What's the basis for copying? Was there a need for that particular photograph to be used? Unless we can get to the need in order to express the subsequent author's meaning or message, why was that particular work necessary? I think we have to understand that, and that has to be a factor in the consideration for determining when a use is fair, when you're wholesale copying another person's work.
Okay. And I would add to that, to push back on Betsy's point that we have to allow or enable wholesale appropriation. We don't do it in the trademark context, right? Where we're talking about commentary and fair use and parody. The test is, that you don't take more than what's needed to, get
For
to the
nominative fair use,
recognition
not
point.
for parody.
I'm sorry?
For nominative fair use, sure, but not for parody.
No, even for parody, you don't take more than you need, right, to make your point, like the Budweiser, Anheuser-Busch case. So why make the distinction for copyright, right? I understand there's different points of IP, but we have to have some thread of consistency, is what I think. And if we say that copyright is there to enable creators to share, to incentivize them to share their works, but also be able to, sustain themselves, right? Then we really, I think, need to be worried about robbing creators of control over derivative works. Because, saying that, the default is you can take it, and then we'll figure out when it's not okay, right? It should be the other way around. It should be, you can't take it, right? This is what the law currently is. Like, fair use is the exception. And the problem is fair use is becoming the rule. And to look at this, this is this case is an example of, it doesn't just affect marginalized communities, right? So I think we have to look at the law and say, we need to look at the law to protect everyone and the purpose of copyright, and especially people who don't have the wealth to litigate every single time somebody takes their stuff, right? And not just go to court the first time, but to go all the way up, right? And possibly have to go back down and come back up again, right? So I think, I tried to stay neutral, but that's my 2 cents. Any closing comments, Lateef or Jeff or Kevin or Philippa or Sandra? Yes, Jeff.
I'll keep it brief, but the derivative right is kind of this seemingly long forgotten right. Whenever you contact, as an artist or creator, you contact an infringer, they'll say, or a potential infringer, they say, it's a derivative. I made a derivative, so it's allowed by copyright law. So there's huge misunderstanding about even that the derivative, the right to adapt a work is one of the core rights held by a copyright owner. And then secondly, that derivative right is as important, or perhaps more important, than the right to reproduce, display, and distribute. Because the right to reproduce, display, and distribute has no worth whatsoever if other people can just copy your work and reproduce, display, and distribute that copy in competition with your own efforts. And lastly, it's not just, people tend to think of the fourth factor as something like competing sales, right? It's usurping the marketplace can happen in many different ways. It can be related to the social or economic level of the artist. It can be related to the need for someone who's created the original work to have that work attributed to them as the creator, rather than to another party who has made a derivative work based on it and added something to it, and then claims it as their own. It's kind of a shifting of the attribution of the creation to this other person. And so we should never downplay or underestimate the importance of the derivative right.
Completely agree, Sandra.
Yeah, I guess I would just end with a plea to both artists and their representatives, whether they are in the BIPOC community or in other communities, as well as to lawyers and judges generally, to talk about art, to talk about what is original in art, and to help lawyers, help judges and their clerks trace original expression from the inception of the artist's idea and its delivery onto the from the camera lens onto the paper, the screen, whatever we now put them on, put photographs on, or the artist's inception of the idea onto the canvas. So that judges can understand what is in fact original about visual art. I mean, that's how art became protectable and copyrightable in the first place. Read Sarony, read Bleistein, read about how these works became protectable, and stop being afraid of talking about art.
Thank you, Kevin.
Yeah, so I'll end with a quick anecdote, which gets back to, I think, the point Tim was making. I was doing a panel yesterday evening on this case with a group of law students who are mostly not familiar with the case, and we showed the two works side by side on a projector and asked them what the different meaning or message was in the Warhol work. We heard a lot of different things, none of which had to do with, changing Prince from a shy person into an iconic image or whatever Warhol Foundation is arguing. And I think that's the problem, with assessments on meaning and message. It's just so subjective. So I think you have to move towards a standard of how it would be reasonably perceived. And then just going back to the question presented in this case, which is a narrow one. I think if the Supreme Court was to say that the Second Circuit is wrong and that mere difference in meaning and message is sufficient to transformative use, that would make transformative use just so easy to demonstrate that it would make factor one essentially meaningless. And so I hope, however the court decides, that it recognizes that transformativeness is not sort of the end all be all, and that all four factors should be applied on a case by case basis.
Thank you. Loletta?
I just wanted to add, no matter how this case turns out, in response to Sandra and Jeff's question, first of all, with regard to registration of works and then sort of the community outreach and education, I think this is where law school clinics can come in and other community service organizations. As a law school clinic clinician, and my role in working with artists, it is to educate them about the meaning of copyright and what their rights are. We also perform registration services. So you guys spread the word that, the artists in marginalized communities and artists who can't afford to register their works, their law school clinics reach out to them to have their works registered. Law school clinics, I challenge any clinicians on this call. We should be in the community educating artists, educating inventors about their rights.
I join you in that. I've been doing it for the last 8 years at George Mason, and I'm really glad to see you now at GW and joining us in the clinic's fight to preserve the rights of artists and creators. And I'm so glad that you're here and will be working with us arm in arm on this. So welcome to the DC community, and I'm so glad that we'll all be colleagues in this fight.
Lateef, did you want to add anything?
Yeah, well, I guess the only thing that I would add, first off, is that, I had a chance to look at some of the other briefs, and, the point that Kevin made is very well taken. Peter Manel wrote a brief about that, this really is a good opportunity for the court to come in and to try to fix this confusion between transformation and derivative work right. So hopefully, at the very least, again, however the decision comes out, that the court will at least take up that challenge and give us some better parameters and some better guidance. And I think that overall, from a social justice perspective, of course, we think social justice is a really good thing. I mean, we think fair use is a really good thing, right? So this is why I think a lot of us are we're technically on opposite sides just because of what we filed. But as you pointed out from the outset, if you listen to everybody, right, we're kind of all saying, yes, we want to support artists. We also want to support artistic freedom. And that we recognize that whether it's a marginalized artist, a small artist or not, they can end up on either side of the equation, right? And so that's why I think that, for me, the better thing to do is to, rather than get into these trying to figure out what were you trying to say, what was your meaning, judges and lawyers assessing art, that's why, our interest was just basically saying, okay, if this were the plaintiff, if you have the typical plaintiff going after somebody and saying, hey, you have copied my work, as Sandra has pointed out, substantial similarity is helpful in us first making the initial cut, right? Do we perceive protectable works, the protectable elements in the first work as being replicated in the second work? If the answer to that is no, if you don't meet that threshold, you don't get to a jury, right? There's nothing to discuss because maybe the similarity comes from the fact that they're both are derived from the same idea. And so we were just arguing, well, let's apply the same approach here, right? That before you can argue transformation, right, let's make certain that you have at least done something, right? Rather than let this get to the jury. Because again, as many of you have pointed out, once it gets to the jury, no matter what you've done, it is always at least possible, right, to make a Monday morning quarterback argument that, oh, yeah, what I did, it means this, it means that, my purpose was da da da. And if you apply the same sort of, you got to at least pass the threshold. You got to at least demonstrate, that there are protectable elements from the first work in the second, or in this case, you've got to show that you at least did something, and that the something that you did is at least, creative, because creativity is a really, really low threshold. But if you can't pass that threshold, then we really shouldn't even get it to a jury, because a jury may buy your transformation argument for all the wrong reasons. And then that may be a way to balance the interest of all artists, big, small, whether they are original artists or secondary artists.
Just to add to that point, and this may be somewhat controversial and we have to end, I was just sitting here thinking, okay, so if you want to open the door, right, to appropriation, and then look to see whether the second artist has added something that, is protectable. If their work is protected, right, by copyright, and they're able to exploit, one approach might be to, okay, the artist doesn't pay the prior artist anything, but any exploitation, right, is shared, right? The revenue from exploitation needs to be shared with the original artist, much like, when compositions get exploited, that money goes back always to the copyright owner, of the composition. It doesn't matter if you're using it in a movie or a game or whatever I don't know about games, but whatever the case may be. So that, maybe there's another way to think about this that, would make everyone happy and share the wealth, like literally. Not a compulsory license, that's not what I'm suggesting, but some kind of revenue sharing, even when a work is deemed a fair use that wasn't simply made for the purpose of commenting, to get the message out there, right? So if your focus is to generate wealth, then you have to share. If your focus is only to get your message out there, then okay, you get your message out there. I don't know. Anyway, thank you everyone for your participation in this panel. Greatly appreciate it. Appreciate the questions.